Okay, so our second panelist for today is Dr. Maria Stefania Cataleta, an associate researcher at the Université Côte d'Azur, who will be delivering a presentation on her paper entitled The Protection of Personal Data in the Digital Era, the Role of GDPR. And now I'll hand it over to you, Maria. Thank you.
Thank you. Thank you. Good morning. Thank you for inviting me. Every second, billions of internet users give web giant huge amounts of personal data transmitted all over social networks, equating to an annual market value of $1 trillion. According to the McAfee law, the value of a network grows exponentially in relation to the number of users. The problem that arises concerns the protection of this patrimony of data, mainly personal data, because this data is one of the sectors most involved on a daily basis by the arrival of artificial intelligence systems. In the digital world, the right to privacy is protected by international treaties such as the Universal Declaration of Human Rights, Article 12, the International Covenant on Civil and Political Rights, Article 17, in addition to regional instruments such as the Charter of Fundamental Rights of the European Union, Article 7. Despite the legal protection, the right to our privacy is constantly undetermined by the use of the internet, which constantly is fed more information. Despite the legal protection, the right to our privacy is constantly undetermined by the use of the internet, which constantly feeds more and more information. This can be provided with our consent, but also fraudulently extracted and used by criminal networks to extort us for money, by governments to carry out mass checks, or through more mundane ways such as by companies to model their advertisement according to our personal profile. While digital communication has on the one hand revolutionized the world of work and interpersonal relationships, it has on the other hand made our privacy more fragile, making it more permeable to violations. At European level, limits to the intrusiveness of digital evolution on citizen rights to privacy were posed by the European Union General Data Protection Regulation. The regulation reduces the freedom of companies in their management of data. However, according to the principles and provision of the GDPR, there are some criticisms concerning personal data. First, the problem of the purpose of the technology is present, seeing as in Europe, artificial intelligence functions can only be carried out for specific purposes. With respect to this aspect, it is necessary to warn against the dangers posed by artificial intelligence, which in the early stages of its operation processes the data predetermined for determined purposes, but that in the field of machine learning, its ability to adapt and consequently change its behaviors, it could begin to process those same data for purposes other than those set out in advance. All this cannot escape the control of the data subject and data controller. Another difficult aspect is that of the processing of multiple information by AI systems. Oddly enough, it is not uncommon for such systems to also obtain sensitive personal data, such as health or sex life attitudes, from the processing of non-personal data. There are some problems related to AI and data protection that, if remain unaddressed, according to the respect of ethical and normative canons determined by the GDPR and other sources, can turn into unfair advantageous opportunity for the operator. Regarding the GDPR, recital number 75 speaks to the risks to the rights and freedoms of physical persons that may result from the processing of personal data at the discretion of out-of-control AI systems or in the wrong hands, and therefore liable to cause physical, material, or immaterial damage. In particular, the recital warns against data processing, which may involve discrimination, theft or misuse of identity, financial loss, damage to reputation, loss of confidentiality of personal data protected by professional secrecy, unauthorized decryption of pseudonymization, or any other significant economic or social damage. It also provides for where data subjects risk being deprived of their rights and freedoms or prevented from exercising control over personal data related to them, or where personal data would like be processed to reveal racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, health data, or data relating to sex life or criminal conviction and crimes or related security measures. There are cases in which the data processing leads to the assessment on personal aspects, in particular by analyzing or forecasting aspects relating to professional performance, economic situation, health, preferences, or personal interest, reliability or behavior, location or travel in order to create or use personal profiles. In the end, there are cases in which data are processed on vulnerable physical persons, such as children, or data processing involving a large amount of personal data and data subject. In recital 76 of the GDPR, it is stated that the probability and the severity of the risk to the rights and freedoms of the data subjects should be determined with regard to the nature, the scope, the context of the processing. The risk should be considered on the basis of an objective assessment where it is to be established if the data processing operation involves a risk of a high risk. In recital 77, encouragement is given to adopt a code of conduct, approved certification, guidelines provided by the Committee of Informatics and Liberties, or guidance given by a data protection officer. It is clear that while in the past the aim was to protect the private citizen from state interference and abuse of power, protection against the misuse of personal information at the present call into question the role of individuals who often offer their own personal data voluntarily to private companies in exchange for advantages. Internet users, in fact, make possible willingly or otherwise the reconstruction of their own individual profile through cookies, geotracking, and consent to the sale, or sometimes fraudulent acquisition of their own data. Scholars have pointed out that human rights lose their meaning in the case privacy, where their use can be traded like any other commodity in exchange for money or other advantages. The free sale of privacy ends up allowing totalitarian control by those who manage this information to learn about, to pilot, and to guide through statistical analysis the personal choices of the same users in exchange for utility. This information given to the public web record on the precondition of democratic participation in online life. In this way, the logic underlying human rights will be reversed, as they will be invoked to protect individual choices as an expression of freedom, ending, however, to be manipulated by power centers, the second in which these companies were to acquire the domain over these personal informations. The great power of the individual now contrasts itself against that of the ever-diminishing authority of the state, destined to succumb to the free will of the individual over his own control of his own rights. Yet these rights, unfortunately, are now being given to centers of political and economic power, that is the creator of AI, who are able to manipulate them in order to redirect individual choices. There is no longer the big brother of the state that watches us, but there is an individual increasingly eager to be supervised. In the digital era, the GDPR represents a limit to the interference of AI to our rights to privacy. Thank you very much for your attention.